I'm Nick Lees. I'm a commercial litigation partner at Walker Morris. Against the global backdrop of Covid-19, two legal concepts have been widely discussed during the crisis, which are force majeure and frustration. So what do these terms mean, and how can they be of practical assistance when managing contracts in a supply chain? In our working lives and home lives, we all know from our experiences that it's caused extreme short-term disruption, and there's real concern about longer-term economic impact and strains on contractual relationships as parties become unable or unwilling to perform their obligations due to the government-imposed lockdowns, illness in the workforce, or problems in supply chains. The UK government issued a paper in May 2020, which is not law and not legally binding. It was asking parties to act reasonably and proportionately in a spirit of cooperation to try and achieve practical, just and equitable outcomes, having regard to the other parties they're dealing with, available financial resources, the protection of public health and the overall national interest. So the government's been encouraging negotiated outcomes to contractual issues arising in supply chains. And that's sensible because litigation can lead to binary outcomes. So in that respect, the government guidance is understandable. But there are times when parties' interests are served by going into the legal toolbox and using the tools available to push a legal position to support the overall commercial objective. And force majeure and frustration are the two things which might be available for parties to consider. So considering first of all force majeure, there's no specific legal doctrine of force majeure in English law. They're a contractual device which regulate the consequences of events beyond the party's control after a contract's been entered into. And the precise effect will depend on the words used in the contract, but generally they operate to excuse parties from performing the contract, and they require a link between the event, which is beyond the party's control, and the inability to perform the contract. And then they'll set out the consequences of what happens, which will usually be a suspension of the contract with no liability, normally leading to an express termination right after a period of time has elapsed. So there's no one-size-fits-all analysis, and each contract needs to be considered against the relevant factual background. But if parties haven't done so already, we'd recommend looking at force majeure clauses now, particularly as a second wave is contemplated and possibly further lockdowns might come, impacting again on supply chains. So after force majeure clauses, the next port of call is the common law doctrine of frustration, where there's no express force majeure clause and parties are looking at their options for contractual relationships. There's no English case which considers frustration caused by a pandemic, even dating back to the Spanish flu pandemic of 1918. So this might become an area where we see more cases developing the law. Frustration operates so that a contract's discharged or ended by operation of law automatically, irrespective of what the parties might want, where after the contract's made, unforeseen events occur which, through no one's fault, make performance of the contract illegal, impossible, or something radically different from what was contemplated when the contract was made. The response to the pandemic, the lockdown measures, focused on freedom of movement and resulted in some businesses having to close their doors or fundamentally change the way they do business. But the legal regulations which were introduced in the UK to achieve lockdown, they didn't specifically make supply chain activity illegal. So with frustration, we think the inquiry is going to be focused on impossibility of performance or a radical change to the state of affairs of what was contemplated between the parties when they contracted. So again, each contract is going to need careful consideration. But we think, in summary, our view on frustration is that it's going to be quite a high bar to get over to establish that a contract's frustrated. But in some circumstances, certainly frustration may provide parties with a mechanism for ending contracts that are no longer viable for them.